Revolutionary greetings, fellow teachers, mainly ATUSI members and all teachers in general. Today we want to discuss an important topic of collective bargaining. We've been running this campaign for a very long time, but we realize a lot of our team members are not grasping the idea, the concept underpinning collective bargaining. Whenever we get to a school, the first question we are asked by a teacher is, when is our salary going to be increased? Ordinarily, it should be easy to answer that question if we genuinely had collective bargaining. But unfortunately, the government of Zimbabwe is reneging on the provisions of the constitution with regards to collective bargaining. People will remember that the most important thing that we celebrated as workers in the 2013 constitution was the right to collective bargaining. It was provided for in section 65.5, but also read together with section 2031B of the constitution. Section 2031B of the constitution mandates the Public Service Commission to engage in collective bargaining whenever they fix conditions of service for the civil servants. Now, the only people who are excluded from enjoying the right to collective bargaining are the workers in the security sector, and those workers are defined in section 207 of the Constitution of the Republic. These are members of the defense forces, the police services, the prisons and correctional services, and intelligence services, and any other security service established by an act of parliament. Now, we have this right, but our employer is denying us the right. Our employer has remained stuck in a process of consultation, refusing to engage in genuine collective bargaining. Some will want to know what is the difference between bargaining and consultation. That definition can be found in a case law, in a case between the Metal and Allied Workers Union versus Hart Limited of 1985. In that case, it was ruled that there is a distinction and substantial difference between consultations and bargaining. To consult means to take counsel or seek information or advice from someone and does not imply any kind of agreement, whereas to bargain means to haggle or wrangle so as to arrive at some agreement on terms of give and take. The term negotiate is akin to bargaining and means to confer with a view to compromise in an agreement. So this is how collective bargaining is different from consultation. Now, scholars like Love Duku have already hinted how public servants in Zimbabwe are denied the right to collective bargaining. As way back as 1997, Professor Love Duku said, it has been indicated above that there is no collective bargaining machinery strictly to be called in the public services. Issues such as levels of frequency and subjects of bargaining at the workplaces do not arise. In undefined consultation takes place, but the extent and modus operandi are neither systematic nor capable of being reduced to some form. As there is no systematic collective bargaining, wages and other conditions of employment are fixed by the Public Service Commission, acting at its sole discretion in terms of its enabling legislation. It is clear that the Commission needs to consult the workers in promulgating regulations determining their terms and conditions of employment. In this regard, the courts have not been helpful. So indeed, the courts have not been helpful. Even in our case, we also approached the courts, trying then to seek the courts to intervene, to say we need to see the implementation, full implementation of Section 5.5, full implementation of Section 2031B of the Constitution. And we wanted the courts also to declare that some sections of the Public Service Act are annulled. Of course, the case was dismissed on technicalities. But now there was a window of hope. A window of hope when we were told that the Public Service Act was now being amended. And we participated in the hearings to contribute to strengthen the Public Service Act so that it captures the latent spirit of Section 2031B read together with Section 65.5. But when they brought the Public Service Act bill to us, we read it and tried to see if that bill was in sync with the Labour Act, was in sync with the Constitution, was in sync with the Article 2 of Convention 154 of ILO. Unfortunately, the proposals fell short of Section 2 of the Labour Act, which reads, collective bargaining agreement means an agreement negotiated in accordance with the Act, which regulates the terms and conditions of employment of employees. But again, that was not captured, even that simple provision from the Labour Act. No, so if we read clause 17 of the proposed amendment bill, which is now at committee stage in Parliament, and we have still made our recommendations, and the legal committee of Parliament has also made an adverse report of the same bill, and we are still pushing that reforms are made. Areas that we are fighting include Section 19 of that proposed bill. In Section 19, there is no way where they mention collective bargaining. What they simply state is that the fixing and regulating of conditions of service shall be done by the Commission with the approval of the President on recommendation from the Minister of Finance after consultation with the Minister of Public Services. So there is no reference whatsoever in that under that section to the term collective bargaining. So it is still falls way below the threshold expected by the Constitution of this Republic, by the Labour Act, and by international law, particularly ILO Convention 154, looking at Article 2. But then the most problematic section of the Public Service Act now becomes Section 20, where they state that the Commission shall engage in regular consultation with recognized associations and organizations in regard to the conditions of service of members of the public service who are represented by the recognized associations or organizations concerned. Then they go on to say, notwithstanding subsection 1, conditions of service fixed or determined under this act shall not be invalid solely on the ground that A, they were not subject or prior consultation in terms of subsection 1, or they were not agreed to by all parties to any prior consultation in terms of subsection 1. So this section completely invalidates all the wording that might be in Public Service Act that try to point towards the idea of collective bargaining. So we are still pushing that those reforms are made. And then again, we still have a serious problem where really they want to defer the question of collective bargaining to then say public service, some regulations are going to be gazetted, which then speaks explicitly to collective bargaining and collective job action, which we don't agree to. We want collective bargaining to be legally binding in the Principal Act. Now, currently, what do we have? We have the National Joint Negotiating Council, established by Statutory Instrument 141 of 1997. Now that statutory instrument is no longer in sync with the provisions of Section 3031B and Section 655. That particular provision, those particular provisions provide for genuine collective bargaining, but the NJNC was created as an animal for consultations. Consultations are not bargaining. So when we send members of the Apex Council who really want to go to the NJNC, they go there, they sit there. But when they sit there, they don't bring anything tangible because they are merely consulted by the employer side. As Amalgamated Road Teachers Union of Zimbabwe and also the Federation of Zimbabwe Educators Union, we've made it clear that we don't want to participate at the NJNC because the NJNC must be dissolved. It's an illegal entity because it is no longer in sync with the Constitution of Zimbabwe. It is now an animal that is ultravious the Constitution of the Republic. So we need to create genuine collective bargaining chambers, and we are glad we are making progress with the reform of the Public Service Act. And what are we proposing going forward? We have said we looked at the countries like Botswana, we've looked at Namibia, how they've created their public service collective bargaining councils, and we are saying Zimbabwe needs to create a umbrella public service council, but below that umbrella, each sector should have a sector-specific bargaining council. So at every sector, so we have education sector collective bargaining council, where we go and discuss sector-specific issues. But there's other issues that are discussed at the umbrella level. So we are then going to be having the federation of the teacher unions, be it for ZANU, or whatever, They meet with the employer at that level. The employer should deploy negotiators who have a mandate to make decisions. And when decisions are made that are binding, this is the only way we can be able then to tell our members to say when is your salary going to be improved. Now, these are not new things. You go to mining, you go to other sectors in the private sector. They are bargaining. At the beginning of the year, I was reading the bargaining agreement from the banking sector's union. They got a good deal where the minimum worker is now earning $750. So we should be able to be bargaining at the beginning of the year. As a sector and also as civil servants. Now the challenge is currently we are waiting for Mtuli Mumbe to tell us that there's going to be an increment in the first quarter. Then the next thing that you have to wait for job evaluation. But at the end of the day, we don't get anything because we don't have the powers to bargain. But now, lastly, I also want to emphasize that collective bargaining is strengthened when the unions themselves have membership. You can't go to the bargaining table when you are representing anyone. The employer will not respect you. Even now, when we are demanding right to collective bargaining, we urge civil servants, we urge teachers to join us in this fight. It is the fight of our life. If we call for a strike demanding the right to collective bargaining, we want to see all civil servants participating, because the right to collective bargaining gives you the right to a fair wage in future. If you can't bargain, you can't then demand a fair wage. But we also strengthen our right to collective bargaining by deploying our right to collective job actions. So don't be intimidated when we call for collective job actions. They are a build up for us to enjoy our right to collective bargaining. And then ultimately, we improve our conditions of service. Currently, we are losing a lot. What have we lost? We have lost our leave days. We used to have 123 or so vacation leave days. They were unilaterally changed. Those terms of conditions of service were changed by the employer without engaging in collective bargaining. Unilaterally, our days will now go for 30 days or so. We have seen the introduction of the GEMS scheme. It was imposed on us, and people, you are losing 2.5% of your income to a scheme that you never signed up for. This should not be done if we genuinely engaged in a collective bargain. We've seen our salaries were slashed in pre-October 2018. We have seen how we've had our the retirement conditions being changed unilaterally by the employer. We've seen how our bonus packages have been changed. All that has to come to end, and we can only put that to an end through pushing for genuine collective bargaining. So, comrades, it is our collective duty to fight for collective bargaining, and when we call for job actions to fight for collective bargaining, take heed of the call. But is it in isolation? I also want you to link it to the issue of the proposed amendment number 3. Now, we have seen how this government also wants to unilaterally change the conditions of service. They got into an agreement with the citizens in 2023 that you will be in office for 5 years. Now we are approaching 2028, where they're supposed to be living. They are unilaterally changing the conditions of the agreement. They now want to go to 2030. This is a classic example of why we need collective bargaining. And at national level, we bargain from the streets, we bargain from the courts, but we bargain as a collective and ensure that the side of the elites in power do not unilaterally change the agreement. We have the social contract which we wrote in 2023. So these are two things that are similar, and we see the violations being done by the same government. We will expect to hear your feedback. This is our position on collective bargaining, and we'll give you more updates on proposed actions, and we expect to hear more proposals from below. Thank you so much.